Good morning, good morning. Glad to be here with you guys today and talking about a very interesting topic, I think, defending against the reptile strategy. So when the reptile sees a survival danger, she protects her genes by impelling the juror to protect himself and the community. Some of you are probably thinking, what in the world does this have to do with defending a lawsuit? And you'll find out in just a second. But Reptile, the 2009 Manual of the Plaintiffs' Revolution, discuss this strategy. So what exactly is the reptile strategy? Well, it's a trial strategy for plaintiffs' attorneys, and the goal is to get the juror's brain into what they call the survival mode, a mode controlled by the R complex of the reptilian brain. So what exactly is the reptilian brain? Well, according to Ball and Keenan in the book, a Dr. Paul McLean of Yale Medical School and a National Institute mental health physician and neuroscientist hypothesizes that there are three parts of the brain. The reptile strategy deals with the reptilian brain. The purpose of the reptilian brain is to protect your genes and to preserve them for the future. The notion behind the reptile strategy is that when your well-being or your quote-unquote genes are in danger, the reptile takes over. Keenan and Ball gives an example that just as the fastest running occurs when running for one's life, so does the most powerful decision-making occur when survival is at stake. So the plaintiff's strategy is to frame their case in terms of this reptilian survival. So a major axiom of the reptile strategy is when the reptile sees a survival danger, she protects her genes by impelling the juror to protect himself and the community. Now, opponents of the reptile strategy say that this strategy is not based on the law, that it preys on the fears and the survival instincts of the jurors, and it focused the jurors not on the facts of the case, but on the potential danger the act of the defendants could have caused to the community or to the jurors themselves. It's important to understand that a major principle in the reptile strategy is the safety of the community is a legitimate concern. So therefore, the goal is to show to the juror the immediate danger and to get the jurors to see that fair compensation is warranted in order to prevent or deter this type of activity in the future. Keenan and Ball talks about the fact that in the civil justice system, by default, Americans know that it's there to protect us. However, that's not the case in the civil justice system. So in the criminal justice system, it's there to protect us, but not in the civil justice system. And they give the opinion that this is why mediocre criminal prosecutors with weak, violent cases, even with a high burden, have success when some of the best plaintiffs' attorneys in civil cases with a lower burden struggle to win with those stronger cases. Now the reptile, for that reason, the reptile is not immediately triggered. So you have to trigger the reptile by showing and demonstrating the potential danger. So the reptile focuses on three questions. Number one, how likely was it that the act or omission would hurt someone? How much harm could it have caused? And how much harm could it cause in other situations? Now, these questions deal with the gravity of the potential danger or harm, and it's to demonstrate that a bad outcome occurred that could have been avoided had basic safety rules would have been followed by the defendant. The first question, how likely was it that the act or omission would hurt someone? Now, the plaintiff will focus on the frequency of the harm. freak accidents rarely trigger the reptile. Why? Because they're called freak accidents, because freak accidents cannot be prevented. The reptile is triggered, however, when something happens often. So in this particular phase of the strategy, what will happen is plaintiff's attorney will use statistics, numbers, to demonstrate the frequency. For example, defense experts will testify that it is rare that sinus infections cause or lead to rare cases of brain abscesses, like a subdural empyema. Plaintiff's expert, using the reptile strategy, will counter, and they will say, well, 10 and 50,000, 20 and 100,000, whatever that number is, in those cases, sinusitis does occur, and it does cause these brain abscesses, and therefore, the doctor should have diagnosed it, and therefore they were negligent and committed malpractice. So what does the number do? The number speaks volumes, okay? The number makes it a real possibility that the juror can relate to. It makes it more concrete. And even though in some occasions, or some cases, the number still may represent the rare nature of the occurrence, but just by giving that number alone, the jurors can somehow relate and make sense of it and say, wait a minute, this can happen. How much harm could it have caused focuses on the maximum harm the act could have caused and not on the actual harm caused. So with this particular question, the plaintiff's counsel is not going to focus on the fact that the rear-end accident at 5 miles per hour caused a minor case of whiplash. They're going to argue that these types of accidents often lead to death, or that the piece of equipment that caused the fracture to the plaintiff's toe could have led to death. So they're going to focus on the maximum harm that could have been caused in that situation. And the goal is to trigger the reptile, to make them say, oh, we need to do something about this. We better award some fair compensation in order to prevent this from happening in the future and endangering the community. The next question focuses on how much harm could it cause in other situations. Now, this attempts to explain how the harm in question can be analogized to other situations. The danger or the harm that's the subject of the lawsuit may not be familiar to the jurors. So the goal is to compare the harm in question to other situations more familiar to the juror. For example, and my background is a lot in medical malpractice and things, so I'm using those examples. For example, in closing argument, plaintiff's counsel will argue that the doctor needlessly endangered my client by operating on the wrong leg. And this is no different than the truck driver running the stop sign and running into the newlyweds in their car. Both parties, the truck driver and the doctor, place the public in danger and in harm. So the point is that I would probably assume that many people don't have personal knowledge of having the wrong body part operated on. Some do, hopefully most don't, but more people have experience with auto accidents, right? And so they analogize that situation to something that most people can relate to. Therefore, with the goal to trigger the reptile and let the jurors do something to prevent it from happening in the future. The umbrella rule. Now, this is the widest general rule the defendant violated enough to encompass every juror's reptile. The plaintiff's counsel will first establish the umbrella rule. Once the umbrella rule is established, case-specific facts are established. So, for example, doctor, you would agree that a lawyer, an accountant, or a doctor should not endanger the client that hired them. Well, I can agree with that. Next question would be, you would agree, doctor, that a doctor should not endanger his or her patient. the doctor would say, yeah, okay, I can agree with that, if they're not properly prepared, but I'm just giving these examples. And the last question is, under no circumstances you agree, doctor, that a doctor should not needlessly endanger their patients. I agree with that. And why not? And that's the nervous question. Now you're hoping that that open-ended question is going to make or break the case at that point, and hopefully he's prepared and he understands what he needs to say and how he needs to respond. So once the umbrella rule is established, they go to more case-specific rules. And examples of that would be, doctor, you would agree that a patient who presents with complaints of chest pain, who has a history of heart attacks, should be tested for cardiac enzymes, because otherwise the doctor would needlessly be endangering their patient. And the doctor responds. And you would agree, doctor, as you already testified to, that a doctor should never needlessly endanger his or her patient, correct? So in order to be prudent, doctor, cardiac enzymes should be tested on the patient who presents with chest pain and who has a history of a heart attack. So a prudent doctor would not, and so in order to be prudent and not endanger the public and the community, you see how they get the public and the community always in there in order to trigger the reptile. So in order not to endanger the public or the community, a patient who presents with this symptom and this history should be tested for cardiac enzymes. And so the goal, once again, start off with the broad umbrella, go to more case specifics. A colleague of mine calls it the funnel trap. The funnel starts off nice and wide and it gets smaller and smaller and it sucks you in. And so if they're not properly prepared, it's going to be hard to get out of that vacuum. So defending against the reptile. So what can we do as a defense attorneys to defend against the reptile? Well, first and foremost, and I cannot emphasize this enough, is you have to recognize the setup. If you recognize the setup, you're going to be able to do what you always do as attorneys, and because you'll see, as I discuss these things, the other stuff is pretty much second nature to a lot of us who've been practicing for a while. And the setup starts as early as the pleading stage. And certain buzzwords to look out for: safety, needlessly endanger, safety rules, danger, unnecessary risk, profits over people, those sorts of things. And as the last presenter just stated, they want you to answer "I don't know" as many times as possible. And so you want to be able to prepare them. Now, in the pleading stage, you want to ensure that plaintiff's counsel complies with the law. Because what they do is they use these buzzwords in an attempt to establish new areas of the law, and it's not based in the law. So you want to be prepared to file motions to clearly frame the issues at the pleading stage. Too many times we get complaints in, and especially with younger attorneys, what they want to do is they want to answer the complaint. Deny, 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 without sufficient evidence, and they haven't looked at the complaint close enough to see that the plaintiff has not pled a proper cause of action. So you want to clearly frame the issues based on the relevant law and not based on a quote-unquote new law. So once the issues are clearly identified, you want to prepare for discovery. In written discovery, you want to be aware of counsel's attempt to establish these new standards and these buzzwords in the interrogatories as well as the request for production. So you want to watch for these buzzwords in those particular documents and requests. You want to be prepared to make proper objections in the written discovery, vague, overbroad, unduly burdensome, unlikely to lead to admissible evidence at trial. If it's a federal case, not proportional to the needs of the case. You want to thoroughly prepare your client for the reptile tactics. And the first step in doing so is to prepare yourself. You have to understand what they're trying to do. You have to understand the buzzwords, okay? and you have to educate your client on the same. At deposition, also, focus on the actual legal duty. You've already made the issues clear at the pleading stage. So now you know what the elements that are at issue, and you should know how to defend against those. But keep it on the elements and what the plaintiff has to prove, and you defend against that. You may want to consider filing a motion for a protective order to limit certain testimony. Be prepared to make objections at the deposition to protect your client, and consider having them heard before the trial. You want to avoid using standing objections. Why? Because with this particular strategy, there are a lot of different ways it can be framed, a lot of different buzzwords, so you don't want to run the risk of having a standard objection that doesn't apply to a specific question that should have been objected to. In preparing your client, you want to obtain transcripts of counsel using the Reptile strategy. Mock depositions are fantastic. If you can't get your hands on the transcripts, you can have one of your attorneys at your firm to act as the main plaintiff's attorney using the Reptile strategy to properly prepare your client. So the key at the deposition, again, in every phase in defense against this strategy, is to focus the case in the court on the law and prevent counsel from creating new law in the form of safety rules. At pre-trial, you want to be prepared to file your motions in limine. As you know, those are very important, could make or break your case. Have pre-trial memoranda all ready to go to defend against this strategy. Jury instructions are very important. Be alert for proposed non-pattern jury instructions with these buzzwords. And at trial, be prepared to make appropriate objections if they're there, and as well as at trial. So the bottom line, ladies and gentlemen, is that this is a very creative and I think clever strategy, and it can be effective if you're not properly prepared to defend against it. So I think if you're able to recognize the setup and you're able to defend against it using your excellent lawyering in every phase of litigation, you can effectively and zealously defend your clients. Thank you.